So here we are again. As some of you may remember, it was exactly 1 year ago today, I think, at this conference, during this conference, not at this conference, but during this conference, that the Department of Labor's rule was overturned by the Fifth Circuit. So there was a lot of scrambling, and during lunch, everyone was trying to read the opinion on their little phones. So a lot has happened in the past year. The DOL has stepped back. The SEC has stepped forward, as well as the states and Congress, actually, in many respects. We'll start with you, Christopher. We have here what I call 3 fiduciary forecasters. So we'll see what we can forecast for you, and you'll decide whether we were right in a few months. Where do you think the SEC is going to land with this package of proposals, and what are the political dynamics at play here?
Well, first I have to say something that my friend and colleague Kevin would probably say. We're having fiduciary dessert right now, so I think they did make a mistake, though. It's not fiduciary flambe or fritters or fortune cookies, but nonetheless we'll try to make this entertaining over dessert. I definitely think the SEC is going to adopt this as a package. I think we heard that yesterday and today. So regulation best interest, Form CRS, and the interpretive guidance for advisors all as a package. One thing we haven't talked about much, which I don't think is going to advance, which is good, was their comments on additional rules for investment advisors, financial responsibility, continuing education, federal licensing, account statements. That doesn't seem to be going anywhere, which is great. I recall back in 2013 when the SEC had a concept similar to those rules, and Schwab surveyed 700 of our independent advisors on our platform, and we estimated at the time, not the exact same rules, but similar rules would cost the industry $1.8 billion to implement. So when we're talking about cost-benefit analysis, I think that one would have a long way to go. But the conduct proposals themselves, I think they will be adopted as a package. The timing on that, I think, would be overestimating that they can get that done in the next month or two. They've got a lot of work to do. Hopefully by third quarter. As we know, it's a priority of Chairman Clayton. But they have a lot of work to do, and I'll be happy to talk about some of that work in a minute.
And by the way, we obviously, I shouldn't say obviously, but I think I mentioned this last year. We opposed those 3 extra goodies, if you will. The requirement that advisors submit account statements, clients already get account statements. The requirement that the SEC have a licensing regime and continuing education for your employees when the states already have such a regime. And finally, the financial responsibility rules, which are really inept, square peg, round hole for investment advisors, because we are not holding the client's assets. I know, Marianne, you have a few views on that.
I do have a few views on that. Yeah, I think these were thrown in just for the sense of completeness, so they considered them phenomenally bad ideas, serve no investor protection at all, and with regard to the licensing, I think my comment letter said I doubted that the SEC had the jurisdiction or the authority. If you look at the way the Advisors Act is written and the NISMIA provisions are written, the SEC gets to regulate advisors, states get to regulate advisors, and the people who provide advice on their behalf. It's in the state province, it's not the federal province. So yes, I think I agree with basically everything Christopher said. I think the extras are dead. They've gone out for comment. They've received comment. Unfortunately,
Dead for now.
For now.
For now. Everything comes
dormant.
back.
Dormant.
Everything comes back.
Dormant. Currently dormant. I do believe the package will go through. Unfortunately, I don't think we'll see the kinds of changes to Form CRS that really should be made. I think they will tweak them somewhat. I'm not sure what they'll do with BI. I think the interpretive release will pretty much look like the proposal with maybe a few tweaks around the edges.
And if I may just, if not disagree, add a footnote to your views. I certainly agree that it looks like all three of the rules, as you know, it's 3 different rulemakings, will likely pass. But there could be 3 different votes. There could be a 4-0 vote, and then there could be 2 different 3-1 votes, with the third vote, which was required for adoption, in one case perhaps being Hester Peirce, the Republican, and in another case it potentially could be Robert Jackson, who spoke to us yesterday. So it's going to be a very, I imagine that the politics at the commission level are pretty interesting on this package.
Yeah, and I do think one of the issues, obviously, is, well, is regulation best interest fiduciary, or is it not fiduciary? And that may be where you were taking us next. And you know, if you read the releases carefully, the way I know Marianne has, it's hard to see why the best interest obligation under Reg BI is not fiduciary. So why don't they just come out and say it? There could be some advantages of that. It could forestall additional state efforts to adopt their own fiduciary rules. We'll talk about a few of those efforts later. It could serve to respond, at least in part, to critics who say, isn't this just warmed over suitability? There really isn't anything additionally meaningful here. And most importantly, it would eliminate potential confusion for retail investors. And from Schwab's perspective, that may be the most important reason of all, to really have harmonization of best interest, its fiduciary. Difference between broker-dealers and investment advisors may be the scope of the duty, transactional versus ongoing, depending on the contract your client has made with you. So they do have a lot of work to do, and fiduciary is a question, I think, circulating within the commission. I would think they want to get a unanimous vote if they can, and we heard Commissioner Jackson yesterday. Several things are going to have to change there. Definitely the economic analysis, but I think also making that best interest standard more meaningful, and so that could go a long way to hopefully getting a unanimous vote.
Right, and there may be steps in that direction. I think from our perspective, it probably is more confusing to investors if there are two standards called fiduciary, but they're different.
Right.
So I think there's a risk there, and we would not, if they did not end up being the same, but yet they were both called a fiduciary standard, I think we would be concerned with that. And I think the scope does have a lot to do with whether Reg BI is a fiduciary standard or not, because for advisors, the fiduciary standard applies to their entire advisory relationship with their clients. And in fact, fiduciary is kind of a status, right? You are a fiduciary as opposed to having a fiduciary standard just from a legal perspective. So I do think there could be, in fact, more confusion with two standards that aren't the same being called fiduciary. So it will be interesting to see where the commission lands on that.
But no doubt Chairman Clayton would like a 4-0 vote, or at least a 3-1 vote where one of the three is Robert Jackson. There is some sense that if there is a legal challenge to this rule, that it would be a bit stronger if it was not just gotten through with 3 Republican votes.
Actually,
I'm not, right, go ahead.
No.
I don't find that a compelling case,
That's what I was
but
gonna say, yes.
I know that is a consideration.
I think one of the problems for me when you talk about do we have two fiduciary standards, and I agree, Chris, we're talking the broker is scope, is limited scope, the advisor is full scope, is the fact that the SEC started this entire project at the wrong starting point. The starting point, as far as I can see, should be the broker-dealer exception to the Advisors Act. In the way the structure is set up, the broker is accepted from the definition of investment advisor if the broker's investment advice is solely incidental, We had the rulemaking in the mid-2000s. The rule was invalidated. The SEC came out with a temporary or a proposed rule. They don't even talk about that. They give a little bit of lip service to the history, but they do nothing. They're not withdrawing the proposed rule. So apparently that's still out there. Why don't we start right back where we should, redo a new solely incidental rule? Then if the broker's advice goes beyond solely incidental, the broker is an investment advisor, registers as such, and is is subject to the full panoply of the fiduciary duty. I think that would help. And in terms of what solely incidental might look like, we have what they said the last time in 2005 or 2004 or whenever it was. And I think that's a good starting place. But what we have since then is the new ADV and the concept of regulatory assets under management. And one thing to think about is if you're providing advice that is of a nature that you would count those assets as regulatory assets under management, you're not providing solely incidental advice anymore. So it's discretionary or it's ongoing supervision and management. So I think if we solved that problem, it's not going to solve all the other problems, but I think the rest of the analysis flows more carefully and more consistently from that.
You know, my sense is that's water under the bridge. The debate
I'm not saying it's going to happen.
there would be a certain integrity to it, and it would be certainly more consistent with the statute. But I think the SEC moved in that direction, not successfully, following the FPA lawsuit. Then the next model was what was in Dodd-Frank Act, Section 913, which called for application of a standard that was no less stringent than the standard applicable to advisors under the Advisors Act. Well, the SEC has not, is not moving in accordance with the Dodd-Frank Act. They've come up with a third approach, and I think they'll stay with it unless it is either not adopted by the Commission, which I think we all agree is highly unlikely, or there's a judicial challenge and it's knocked down by the courts, which certainly is possible. The Circuit Court of Appeals has not been particularly friendly to the SEC in recent years, and the cost-benefit analysis, at least according to many, is somewhat infirm, the cost-benefit analysis underlying this rulemaking.
Karen, may I come
Yes.
to the defense of the SEC just a little bit?
Of course.
I think the commission. I mean, the commission is really trying to do some important things here. First of all, they're trying to shine a brighter light on conflicts of interest, and that's a really important thing. They're also trying to maintain a distinction between broker-dealer and the services they provide when it comes to investment advice and what registered investment advisors do. And that's kind of a hard line to navigate. But again, from a retail investor standpoint, we need both services. I mean, there are many clients that don't want, don't need, can't afford ongoing fiduciary service because that costs money. And I think the question is, can you have a best interest standard, a duty of loyalty and care, and a transactional sense that's very clear to investors that it's limited in scope? And if you really want somebody to monitor your accounts, to have an ongoing obligation, you're probably going to have to pay for that, and that's where you go and hire a registered investment advisor. And that's going to be the trick to make sure something like Form CRS actually creates clarity for investors rather than confusing them more. And I think that's where the jury's still out on what we're going to get from the SEC as a final rule.
And in fact, I think earlier we were making the distinction, should that, what you characterized, standard for brokers, duty of care, duty of loyalty, be called fiduciary. And I think you can resolve that issue without calling it fiduciary, or at least not the exact same, distinguishing it in some way, and still have a strong and robust standard for broker-dealers. My point really is, if it's not exactly the same, it may cause
If the only
confusion.
difference is the scope, how about just calling it transactional fiduciary?
Yeah, and I have some research I can talk about when we get to
Well,
it.
we are moving there now, but first we're going to take a small diversion to Capitol Hill, since we are actually within vision of Capitol Hill over here.
So up the escalators, you make a right out of the building, and you're on the Senate side. I'll lead the way. I think what Karen is alluding to, there was a hearing yesterday at 9:30 a.m. The House Financial Services Committee, what used to be the Capital Markets Subcommittee, but it's now called the Investor Protection, Entrepreneurship, and Capital Markets Subcommittee, had a hearing on Reg BI. And I must say that I'm going to take this opportunity to correct a significant misstatement that was made by one of the witnesses at the hearing, in fact, the sole Republican witness. And in defending the rule proposal, former SEC Chair Harvey Pitt, who was the Republican witness, quoted 19th century Prussian military leader Karl von Clausewitz for the proposition that the perfect is the enemy of the good. And this was part of his defense of the proposal, warts and all. Well, let me make very clear his misstatement. And as federally registered investment advisors, as you well know, it was not von Clausewitz, it was Voltaire who made that statement. So I'm hoping that the record will be corrected shortly.
It's a big difference.
It's very, very significant, and I'll be in touch with Harvey Pitt about that. So there have been a couple of press articles about the hearing that I think get it right. The Politico lead was House Dems blast SEC investment advice proposal as weak. Investment News, House Dems call on SEC to strengthen regulation best interest. The Dems were very critical of the proposal. Many of them favor going back to the Section 913 formulation. The Republican and the chair of that committee, by the way, is Carolyn Maloney from New York. The ranking minority member, which is, say, the ranking Republican, is Bill Huizenga from Michigan. He defended the rule, and Maloney was quite aggressive in attacking it. There were a total of 5 witnesses, 4 witnesses picked by the Dems, 1 Republican, and just to give you a flavor, Barb Roper from the Consumer Federation of America said that CRS needs, and she said this quite alliteratively, CRS needs to be rewritten, retested, and reproposed. Scrap it and start again. She said Regulation BI simply codifies the existing FINRA suitability standard. The AARP testified the proposal would further confuse investors or worse, provide them with a false sense of security. In response, Harvey Pitt, again, who was cast in the role of defending the agency and the rule, said, and I find this somewhat odd, the proposed regulations should be seen as an initial step, not a final step. Well, I think it's highly unlikely if this rule is proposed, although it's within the power of the SEC to modify a rulemaking, as we hope will happen shortly on advertising and custody, the things that were discussed earlier. The SEC has been working on this since, 1999, and I think it's highly unlikely in the near term they will revisit it if they adopt the rule. At the end of the hearing, and this may be the most significant thing, Congressman Brad Sherman from California asked each of the witnesses, is the proposal better than the status quo? And 4 of the 5 witnesses said no. The status quo is superior than the rule as currently proposed. Harvey Pitt said it's better than nothing, and there will be an opportunity to improve it later. So is this a lot of sound and fury without consequence? Well, it could influence the rulemaking, but Congress is not going to legislatively preempt the agency. There's been some speculation about that. I think the chance of that is somewhere between slim and none. So I think it will have a limited effect on the rulemaking. I should just mention lastly, however, the hearing was used as a springboard for a piece of draft legislation introduced by, or to be introduced by, a freshman Democrat on the committee, Sean Casten from Illinois. The sole member of Congress with a background in biochemical engineering, I might add, that would require the agency to do rigorous, in-depth testing, investor testing, before any rule is made final, and it would even require the SEC to do testing of existing disclosure forms. He was very critical of the testing done by the SEC, noting that although there was a survey of 1,800 persons, there were only 31 in-depth sort of qualitative evaluations. And I think Christopher will talk about this shortly, but the SEC testing revealed that folks liked this summary disclosure form, Form CRS, Client Relationship Summary. It does not stand for can't remember stuff. But the 31 interviews also revealed that they liked it, but they didn't understand the information that was provided. So I think that legislation could move in the House, but if I had to guess, what will happen to it is what happens to most bills that are passed by the House. The Senate is there to kill House bills. It will die in the Senate. I think it's unlikely it will be enacted into law.
Right, so really the upshot is there have been hearings, there could be more hearings, but Congress is unlikely to have any actual impact on the final rule.
Well, they had the opportunity in Dodd-Frank. I mean, this issue has ping-ponged back and forth between the SEC and the Hill for decades. And when the SEC couldn't solve the question, the Hill tried. They had hearings for Dodd-Frank, and instead of solving the issue, they came up with 913 and said, do a study.
And well, 913 said do a study and gave the agency permissive authority to do a rule in accordance with 913. It did not mandate a rulemaking.
No,
and that's.
But I saw that as a failure of Congress. They couldn't, it was too hard.
I don't know if it was a failure of Congress, but reflected a lot of political viewpoints, and they gave it to the expert agency to figure out. I would say it would be really sad if the SEC does not move forward with final rules, including Form CRS. Now, there's some risk there because they need to get Form CRS right.
Yep.
They have received a lot of input. Schwab alone, we've written 3 comment letters because we feel very passionately about clear disclosures to retail investors. We submitted a one-page alternative. The IAA submitted a great one-page alternative. Fidelity submitted a great one-page alternative. They've not only had the RAND study to go off of, but the consumer groups hired their own expert, so they've got information from the consumer groups. And then Schwab did survey 1,000. We paid an independent firm to survey 1,000 retail investors, and we had some really interesting results that certainly informed the way we're advocating about this.
And by the way, you don't have to take it out now, but the results from that survey are in your materials to read on the train on your way home.
Can I give a couple highlights, though?
Yes, please do.
I mean, because it's very interesting. Everyone says, well, let's do this for retail investors. Let's make it clear for retail investors. Well, go and ask retail investors. It's actually not that hard to do. The results of our survey showed that 80% of them believe they understand what it means to act as your fiduciary. 80%. 96% believe they know what it means to act in your best interest. 96%. It's an astonishingly high number. Do they understand it like lawyers? No, lawyers can't even agree on it. But intuitively, best interest is not that hard. If somebody is giving me advice, they're doing it because they believe it's in my best interest, not in theirs or somebody else's. It's not really a hard concept to grasp. About 60% of those 1,000 investors believe that they should mean the same thing. Fiduciary and best interest should really mean the same thing. And then by a margin of more than 2 to 1, no matter what they mean, retail investors tell us that it should apply to both investment advisors and broker-dealers. That's some very important information, I think, that the SEC should weigh. When it comes to disclosures, this won't surprise anybody. 50% say they either don't read them or skim them at best. What would get them to read those disclosures more? Again, this isn't surprising, but this is right from retail investors. Don't make it look like a legal document. Make sure it's relevant to me, and use plain English, right? So this is all things that the SEC knows. It's all things that we know. It's just going to take some fortitude to actually implement it for Form CRS.
So where do you think actually the SEC is going to end up on Form CRS? I mean, we've all submitted what we think are better alternatives for the form, and in fact, we've encouraged the SEC to employ a layered approach. So short and sweet in the relationship summary, and then you can drill down in Form ADV for more information.
It was very encouraging to hear Director Blast talk about that very concept this morning. It's worked in the mutual fund area to some extent, probably more work to do there. But that's the beauty of this one-pager. ask and answer 5 basic questions for investors, and with each question, link to more information. Broker-dealers like Schwab, dual registrants like Schwab, we already have this information. Investment advisors have this information in your ADV. It's just, can we get it on one piece of paper to say, hey, what advice service do you provide to me, and what's your obligation? How do I pay for investment advice? Do you have conflicts of interest when you give investment advice? Tell me what the 2 most important ones are. How do you pay your people who give investment advice? What additional information do I need to know? And that last section would be a link to disciplinary history, and it might be a link to industry education on the difference between advisors and broker-dealers. Don't make it be part of the disclosure about my relationship with my financial professional, but have a link to that information.
We totally agree with that, by the way, in that brokers should not be saying what advisors do. And when a client comes to an advisor, they came to an advisor. They don't want to see information about what brokers do.
Right.
Right. And there are a lot of different business types and services with both kinds of registrants. I think it's more confusing to investors to come to an advisor and see disclosures about what brokers do and vice versa. What you want is apples to apples. I want this form for advisor A and this form for advisor B, and line up 2 advisors, for example. So
Well, and that was the whole point of the new ADV. It was the whole point of the IAPD. It was the whole point of saying that the brochures had to have the exact same headings in the exact same format. And I went back and when I wrote the comments for Form CRS, I looked at what the SEC said about the new ADV. It was going to be plain English. It was going to be comparable across the industry. It was going to make it easy for people to locate the most important information. It should not have so much information that people wouldn't read it. You tailor it to the sophistication of the client. And it's everything now they're saying about CRS. So are they throwing up their hands and saying the ADV was a big failure? And I agree, and I think my biggest quibble with the CRS is this handing a retail investment advisor client information about a broker, because I think it's just so confusing. And the delivery requirements that say every time they open another account, you give it to them again. So you have a 30-year relationship with this family, and now they're opening a trust or a 529 for their grandchild, and you're going to tell them again, you should really think about going to a broker. Why are you coming to us? It's bizarre. And
in our comment letters, we suggested that the link could be to the SEC's own website. They have an Office of Investor Education that is certainly capable of that. And that would be a link talking about the differences between investment advisory services and brokerage services, the different standards of conduct that apply. Lines do not need to be wasted on Form CRS on this. I think that would be the proper way to handle it.
And a last point is for dual registrants that offer both, that side-by-side is really confusing, right? But you could easily have a one-page document with layered links about your brokerage account relationship. And if you're at a firm like Schwab, where we offer investment advisory as well, at the top there would be a link. If you want to find out about our investment advisory accounts, go here. And when you click that link, you go to the one-pager about whatever the advisory program is.
So we all think we have...
we solved that problem.
We solved
yeah,
it.
we've got it nailed.
We solved that. So we've talked about Reg BI, we've talked about Form CRS. I think there was a lot of good discussion this morning about the interpretation. We at the IAA made the comment that was alluded to a couple of times that the proposed interpretation actually really did not distinguish well between retail clients and institutional clients. And it was very encouraging to hear how the SEC speakers really understood, and I think were well aware of those points. I don't know, Marianne or Christopher, if you want to add anything about the interpretation, where you see it going and how it might affect investment advisors.
I mean, I would say that the SEC staff did a very admirable job, as we heard this morning. They were trying to piece together a lot of history from a lot of sources. My one observation, I hope this will be cleared up both in the adopting release for Reg BI, but also the final interpretive guidance for advisors. There are just these nuances, and whether disclosure is always enough, or whether you have to mitigate conflicts. It just seems to me that they could smooth through a lot of those discrepancies, a lot of those nuances, just to make it much clearer.
Yeah, I agree. And on the conflict disclosure, I thought it was kind of interesting that they talk about disclose unless you can't disclose because you can't really understand the disclosure, in which case you have to mitigate. And I didn't see anything that said you always have to have, you either eliminate your conflicts or you manage and disclose them. And the management is in your compliance procedures, 20647. If you have conflicts and you don't have procedures to address and manage those conflicts, good luck with your next exam. So I think, again, it can be, it doesn't need radical work. I think it needs a little tightening up and a little harmonizing, internally. My bigger problem is, again, on the BI, because if you look at the way they articulated standards in the BI release and in the fiduciary release, they're using exactly the same terminology. And then they're saying, but of course, the fiduciary standard is different from Reg BI. And it takes a far more nimble mind than mine to find the difference in the harmonization when they use the same terminology.
So big picture, what does this mean for the industry, right? So assume they're going to pass this package of rules, and actually we think they will. We think they're going to pass this package of rules. We can argue about whether it's the second quarter, third quarter, and make our forecast, but they're going to pass it soon, right? So Christopher, I'll start with you. What does this mean for the industry? What does this mean for your firm?
Yeah, well, obviously it'll be a new way to conduct business once they're adopted and we know what the compliance effective date is. I assume they'll give us all plenty of time. The challenge we're having as a highly diversified dual registrant is not only do we have the SEC's rules we're waiting on, but we're actually following the DOL's temporary enforcement policy. Even though the Fifth Circuit struck down the rules, if you were, for good reason, relying on those impartial conduct standards, DOL said you can continue to do that if you think you might need an exemption from prohibited transactions. So DOL has not gone away. We've got the SEC. We certainly have the states acting, and then the CFP board. Their new code of ethics and professional standards take effect on October 1. There are 83,000 CFP certificants in the industry, and that includes tens of thousands who work for large Wall Street firms. So that's really our first deadline. So practically speaking, we're trying to figure out how we can help our CFP certificants meet that October 1 deadline while keeping an eye on where the SEC is going to go. So I think for some firms, the big challenge is how do we synthesize this? Because the regulators aren't really doing it for us. If you're a smaller firm or just an independent RIA, you definitely need to be paying attention to what's going on, but we don't really know where this ship's going to land. So you probably, right now, don't want to be investing a whole lot of time and effort developing new policies and procedures, but definitely be paying attention to what's going on.
Marianne, what are you advising your clients, or are we sort of wait and see where everything?
Well, my clients haven't forgiven me for making them get ready for the DOL rule. Well, and all kidding aside, one of the things you might have noticed in the interpretive release, when the SEC says for an investment advisor, the fiduciary duty applies not only to investment making decisions about buying and selling, but all services that the advisor provides. And it says including advising on a rollover into an account that the advisor will manage. Well, that, of course, is the advice fiduciary that was at the heart of the DOL rule. So they kind of snuck that in there. And I said to my clients, see all the work you did on that advice fiduciary, because nobody
Exactly what we said.
They
also.
didn't forgive. They still haven't forgiven me for giving them the checklist of whether this is in the best interest to do the rollover. So I think, all kidding aside, I'm not going to advise people to do anything different yet. I think the challenge is going to be with the CRS in particular. If it doesn't change a lot, I think we're going to have a lot of questions from clients.
And I think clearly there was a coordinated effort, entirely appropriate, where the Department of Labor really wants the SEC to move first, to occupy as much of the field as possible, and then it will act in accordance with it. So I think that was the word that came down from the administration. The SEC is an independent regulatory agency, but Chairman Clayton's a pretty savvy guy. And I think he understood the importance of the SEC moving in this area just as quickly as possible. And I think, as you've heard from other speakers, he is very much committed to get this rulemaking through, and it will. So it's really a question of what's in it.
Yep.
And we alluded to this a little bit in the comments just now, but is the DOL rule really dead? I mean, what the DOL really is, it has been quiet for the last year, but what role will they play after the SEC rule is adopted? Christopher, I'll start with you.
Yeah, I think Neil makes a really good point. They've said we'll hopefully follow the SEC's lead, but who knows who the political appointees at the top of DOL will be in February of 2021, right? I think the temporary enforcement policy was helpful to some firms, especially in that rollover context where it's at best kind of a gray area under the Internal Revenue Code and for IRAs. I do think that they're continuing to talk to the industry. Hey, could there be some type of class exemption based on impartial conduct standards? So they're still active, but I think they're in a wait-and-see mode, both for political reasons, but also for the reason that Neil gave.
So we've alluded to this a couple of times, but now I think we should dig in a little more. What are the states doing in this area, right? So the SEC is on the verge, one presumes, of adopting the rule. But there have been a number of states that have really expressed some concern that maybe either the SEC won't act or the rule will not be strong enough and that they need to step up. Christopher, what states have acted so far or considered acting, and what do we foresee?
Yeah, so the main ones are Nevada, Maryland, New Jersey, New York. They're at various stages. And I certainly understand why the states are trying to fill a void that they see here. It is unfortunate, though, because a patchwork rather than a national standard is not good for anybody, investors or the industry. By the same token, certainly when it comes to smaller advisors, states have a responsibility to regulate them. If you look at the different elements of these various state initiatives, does it apply to both BDs and IAs? Is there a private right of action? Do they simply try to define fiduciary, for example, in an anti-fraud context, or is it a much more elaborate set of rules that look more like they're regulating a lot of business conduct, including books and records? In Nevada, over a year ago, I guess it was, the legislature passed a new law amending their code so that investment advisors and broker-dealers who had been excluded from a financial planner definition and financial planner code provisions were now suddenly swept up in financial planner regulation. And that set off a rulemaking process with the Secretary of State Securities Division. We had those proposed rules. They were pretty lengthy, all kinds of definitions around investment advice for both broker-dealers and investment advisors, a list of fiduciary obligations enumerated, and then for dual registrants basically saying, look, if you're a dual registrant, you really can't provide broker-dealer investment advisor services. You're going to be subject to a continuous ongoing fiduciary duty. And from Schwab's perspective, that's not a good thing because it takes away client choice. Again, a lot of clients don't want, don't need, can't pay for that type of a service. So I think in the long run, that could be harmful to Nevadans. And that's the main point we made in our comment letter. I'll just mention, I guess, Maryland quickly here. In the case of Maryland, it's part of the Financial Consumer Protection Act. It's a bill. They just had hearings earlier this week. It's just one part of a really lengthy bill, and they had testimony on both sides of it, information gathering, but it seems like it might not move forward, is the latest I heard, because it's pretty complicated, caught up in that larger bill.
So, Mary Ann, aren't the states preempted from regulating SEC-registered investment advisors?
Yes. Yeah.
Are you going to qualify that?
Is that a leading question?
It is a leading question, and I'll be led. Yes, the whole idea of NSMIA is to have one regulator in the space for investment advisors. And if it's the big kids, it's the SEC. If it's the little kids, it's the states. NSMIA was not absolute, however. It did allow the states to continue to register certain supervised persons, and it also preserved the state's right to enforce anti-fraud. So the question is, are these fiduciary initiatives just a way to regulate fraud, or are they substantive regulations? And I think with some of them, it looks like what we all know and what the SEC always tells us you can't do indirectly, what you can't do directly. And it looks like an end run. To me, it looks like an end run around NSMIA.
And we have, IAA has, filed comment letters on a number of these state proposals focusing on this preemption issue and making clear that the state's authority is quite limited under NSMIA. However, at the same time, I should mention that there's no case law in this area. So it is worth keeping an eye on these states, and that is something that although we are primarily federally focused, to a lesser extent internationally focused, we are now keeping a much closer eye on state activity than we have before.
I do think it's an interesting question. What will slow down the states? Now, it's not really a tidal wave. It's four or five states, but maybe more will jump into the fray. A really strong SEC final rule, especially on broker-dealers, might do the trick. Lawsuit might do the trick, but certainly the federal courts narrowly construe federal preemption. So that's a concern. And quite honestly, if a state wanted to write an anti-fraud provision, or they wanted to write a qualification provision, wouldn't necessarily be preempted, but those aren't the type of state bills that we're seeing right now.
Right. And as Neil alluded to, we are going to continue to advocate at the state level to remind state legislators that they are not allowed to substantively regulate SEC-registered investment advisors, that Congress divided jurisdiction, and for the most part, the jurisdiction remains with the SEC for SEC-registered firms. So let's head back to Congress, up the street, or is it this way? This way. Congress is involved now in some consideration of major retirement legislation, and that implicates as well investment advisors, investment choices, how folks are going to save for retirement, and what kinds of funds will be in their retirement accounts, and what kinds of duties folks will have with respect to those retirement accounts. So fiduciary is not limited to the SEC, DOL, and the states. We are interested in fiduciary on the retirement account level. Neil, what is happening on Capitol Hill with respect to retirement legislation and its potential impact on investment advisors?
So there's been lots of activity in the last two Congresses in this area. There is a recognition that more has to be done to encourage taxpayers to save for retirement. Lots of aging baby boomers who may not have socked away enough yet for retirement. And there's various proposals, RESA, REPSA, all sorts of names. Some of them have passed one chamber or the other, House or Senate, but they have yet to be enacted into law. There's real interest on the Hill on these issues, and we're watching them quite closely. To date, we weighed in February. I hope most of you are familiar with our Active Managers Council. We are trying to ensure that the debate or the discussion of portfolios is both passive and active, not one or the other, and there's not a conflict, but we are concerned that policymakers, both in the US and abroad, are starting to put their thumb on that scale and limit investor choice and have a bias toward passive. In any case, there was one proposal pushed by Senator Mark Warner from Virginia and Congressman Jim Himes for Connecticut, both pretty sophisticated, moderate, I would say, Democrats. And in an early draft of their proposal, PRIA, Portable Retirement Investment Account, there was a default option, not unlike the early draft of the DOL proposal. And the default option was index funds. And we, in early February, we had members of our Active Management Policy Task Force in town. We had some very productive meetings on Capitol Hill, on both the House side and Senate side, and made clear that we thought it was inappropriate. And I think they got the message. So I am hopeful when that legislation is introduced that it will not evidence any sort of bias. But this is a big issue. I think it's something that we are all going to have to be quite vigilant about. I'm reluctant to handicap the likelihood of this legislation being enacted into law because all these proposals are expensive. They're going to cost the Treasury money. And under rules that were adopted by this Congress, if you have something that is going to cost money, it has to be coupled with a pay-for. So these are the so-called pay-go rules. So if somebody is proposing something that is going to cost Treasury X dollars based on the estimate from the Joint Taxation Committee, it has to be coupled with something that would raise money. Carried interest, reducing the corporate or increasing the corporate tax rate that was cut. Rothification, which we successfully fought.
Right.
Mandatory FIFO. Now, to our way of thinking, one of the best ways and an important way to encourage savings is by not only restoring the pre-existing deduction for investment advisory fees. So before the Tax Cuts and Jobs Act, if you had a client whose itemized business deductions exceeded 2% of their AGI, they could deduct their investment advisory fees. That was eliminated. We are on the Hill right now, or not right now, but very regularly, to not only trying to restore that provision, but we'd like to expand it to all investment advisory fees, because it's not enough that folks just are, they need fiduciary investment advice, the type of advice that you and your firms can provide, and this would be an incentive to that. So this is a big issue. It's going to be a big issue that we're going to be discussing on Advisor Advocacy Day on June 13th, when I hope at least half of this crowd is in town for a lovely day in your nation's capital. But this is a very major policy priority right now for IAA.
And I think we have exactly 2 minutes left, so this is perfect for a quick fire round of top three. So top three takeaways that folks here should bring back with respect to this whole fiduciary debate. Mary Ann.
Your ultimate relationship with your advisory clients won't change. Your clients will be very confused by whatever the CRS you hand them, if it comes out the way it is now. And I'll stop at 2.
Okay. And by the way, I do want to give a shout out to Mary Ann. Mary Ann stepped into this panel at the last minute when another panelist took ill. So we very much appreciate that. I should have said that at the outset.
And I don't think she's done too badly.
I think she's done really well.
But I didn't get the third thing.
Christopher.
My 3 takeaways are really a subcategory of 1. Continue to be involved. Get get involved in advocacy. Certainly, hopefully most of you are members of the IAA, but talk to your local members of Congress, talk at the state level, and there are three messages that should be woven there. Number one is, I think the fiduciary battle is all but won. However Regulation BI comes out, broker-dealers, anybody who gives investment advice should be under some type of fiduciary obligation. I think it has to be plainly explained so retail investors understand the difference, though, between the services they can get. At the state level, don't balkanize fiduciary obligations. It's just going to confuse your consumers in your state, and it's going to be a burden on small businesses, i.e. small RIAs in your state. Third one is listen to investors. Listen to what they want and need. It's not that hard to do that kind of research, and for Form CRS, they need something simple, plain, one page, layered disclosure. So if we all can have those common messages, I think it will help not only our industry, but investors too.
Thank you, Neil.
Long ago, there was a senator from Illinois named Everett Dirksen who said, when I feel the heat, I see the light. You're the folks that can generate the heat. Do not underestimate the importance of your getting involved in advocacy. Writing letters to Congress, we make it easy. We have template letters on our website on all the issues that we have discussed. Come to Advocacy Day, June 13th. Members and non-members are welcome. We consider non-members prospective members, by the way. But get involved. You, as individuals and your firms, can have an impact on these issues, and we need your support.
Thank you, Neil. And I will just add pretty much what Marianne said. Keep doing your best work for your clients, putting your clients' interests first. You know, that will never change. We will always still be fiduciaries for our clients. With that, please join me in thanking our panelists today.